the agenda is the Pledge of Allegiance, and ask Councilman Green to lead us in the pledge.
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation under God, indivisible, with liberty and justice for all.
Good morning, everyone. Welcome to the Space Coast Transportation Planning Organization meeting today. First item on the agenda is the approval of our minutes of September 11, 2014. The chairman entertains a motion. Second. Any discussion? All in favor say aye. Aye. Opposed? Motion approved. Item 4 on the agenda, reports of committees. Number A, CAC committee. Bob, I think you're going to handle that.
Yes, you have a very brief report at your place. It doesn't even take up the back of the section inside, because for the first time in my recollection, we did not have a quorum for either the CAC or the TAC. Very unusual for us. Very pleased that we do have quorum to find everything and work out the attendance, but for some reason we did not. So there were no actions taken, so we have no recommendations to report.
The report. Bob? Next item, 4B, bicycle pedestrian and trail advisory committee. Kim? Welcome to school, bicycle lady.
Yeah.
Your publicity on walking to school.
Good morning, everybody. How are you doing? The Bicycle Pedestrian Trails Advisory Committee has not met since your last meeting. They'll meet again on November 17th, so when they meet again, we'll have minutes for you. We do want to tell you, Florida has put a big emphasis on pedestrian safety because we rank so high in pedestrian fatalities. When they first really started looking at this, they identified 10 counties that were extremely high in pedestrian fatalities, and we were not in it, but they've expanded it to 15, and we rank in the top 15, so we are now included in that. We're not totally sure what all that means. We do know that there's a possibility that there would be more marketing materials and things like that that would come to this area. And just to give you a snapshot of where we are this year with pedestrian fatalities, according to the crash database that we use in our office, we've had 42 traffic fatalities, 14 of which are pedestrians, for a percentage of about 33%. And to put that into correlation with the national average is 14%. So we're more than double the national average. That's not a number we like. So hopefully we'll be able to use this designation as something that can help change those numbers around. On a more positive note, something to end with, yesterday was Walk to School Day. It was the 15th year that the TPO has coordinated those events for the county and kind of marketed them and tried to get the schools to participate, and every year it's gotten bigger and better, and I stand up here and I'm like, what a great success. And again, yesterday was a great success, but I want to take just a minute just to recognize some of the reasons why. We partnered with people like the Florida Bicycle Pedestrian Resource Center, who sent us all kinds of goodies to give out to the kids, and Joan Carter with FDOT, who also provides us with materials. Heather Murphy, she is the network head person for Florida for the Safe Route to the School National Partnership, helped me get 41 cases of fruit roll-ups to send to the schools that were participating, and the staff in my office were not so happy with me for a couple weeks, as the whole office smelled like a version of grape and cardboard. So you can imagine how pleasant that was. But it was nice to have those. I'd also more locally like to recognize, and I don't know all of them, but I do know that they help the police departments, the sheriff's office, the fire departments that either support, or the police officers that come out and work traffic. I know we had to get the sheriff's office traffic unit to cross the kids for Quest Elementary because of the construction. Their normal route had no sidewalk between Target and the traffic circle out here, so they went from Pro Health, which only has a sidewalk on what happened to be the wrong side. So the sheriff's office came out and helped with that. Community leaders like our very own Mayor Meehan, who was out walking with Stone Middle School. Not only did they have Walk to School Day, but they also used it as an opportunity to rally against Stop Bullying. So they added an additional message. And it goes without saying, our partnership with the school board. This is something that enables us, you know, everybody always asks me, and I've said it before, how do you do what you do? And we do it because we have such a wonderful, wonderful partnership with our school board. And they are just amazing people. The principals, the staff, the people I work with, they're just amazing. In fact, their careers, they carried those 41 boxes to every school that they went to. So it saved us the postage, and we hauled them over there, and those boxes weighed about 22 pounds apiece. So thank you to them for that, and we enjoy that partnership and hope it keeps going because it enables us to put out a product that is pretty much second to none in the state of Florida when it comes to bike ed education. So that's my report.
Thanks, Kim. Any questions for Kim? Very important. Very good. Great job that you do, Kim. Item 4C on the agenda, Regional Coordination Report.
Yeah, I'll make this rather brief. We've been talking over the past few months about the East Central Florida Corridor Task Force. They are meeting today and tomorrow. Commissioner Belinda Lewis is the representative from the county commission. She's not here today because she's attending that meeting in Orlando. We're getting down to the wire here and actually engaged in identifying preferred corridors to address the connectivity needs of the Central Florida region. So this is somewhat the purpose of the whole exercise is to get to this point. They need their recommendations to the governor by December 1st. There'll be one more meeting in November. And then we will try to schedule something, hopefully in February, to present the recommendations on the task force work. So I know I've been talking about process, and that hopefully pretty soon we'll be able to see actually what the recommendations are, so we can work that into our long-range transportation plan and follow it up with any comp plan revisions that may be necessary or desired. So we're almost to the end of the task force, and we're very pleased it's been an extremely good group and very engaged, and I think it's going to be a very good study.
Questions for Bob? Okay, moving right along, item 5 on the agenda, the consent agenda. Bob, you're going to read
Yes.
each item.
The consent agenda includes committee appointments. There are no additional appointments from what you have in the package. Finance and budget items. Approval of resolution 15-11, which is an amendment to the Unified Planning Work Program to reconcile our actual grant funds received with what we were estimated to receive earlier on. And finally, a technical correction to our priorities to clarify regional trail projects as requested by FDOT, so they had support to move forward with some of the projects that could very clearly demonstrate that they're in our priorities.
Chair would entertain a motion to approve the consent agenda.
Mr. Chairman, I move for approval.
Second.
Been moved and seconded. Any discussion? All in favor say aye.
Aye.
Consent agenda is approved. Item 6 on the agenda, action items. Number A, resolution 15-12, quiet zone coordination. Bob, that's yours.
Staff's been very deeply involved in working through gaining support or approval, whatever, of coordination of quiet zone designation to have the TPO serve as the coordinating entity to seek a continuous quiet zone from the Cocoa area south to the Indian River County line. In the package is a memo and a template for a resolution that was distributed to the 7 jurisdictions that are affected by the crossing upgrades that all North Florida will be paying for and installing. The last of the jurisdictions to consider was Grant Valcaria, and they did that last night. We checked this morning, they approved it, so we have 7 of the 7 jurisdictions have agreed to the resolution to have the TPO coordinate this activity. I also want to call out in the agenda sheet, the agenda write-up, the last 2 paragraphs under discussion. We've been advised by the FEC railway engineer who's working on the crossing upgrades that as part of the double tracking, FEC intends to double track the line the whole way to the county line and eventually even further north than that. As part of that double tracking, they will be also be installing some crossing safety upgrades north of Canal Rose Boulevard through the unincorporated area and through Titusville. And I was advised by the railroad engineer that it's very likely that many, or if not all of those crossings will also meet quiet zone standards. The standards are a little bit lower because there's not as many trains and the roadway volumes of the cross streets aren't as high. So the standard of protection does not have to be quite as great as it is further south where the trains will be in excess of 80 miles an hour and we have higher volume roadways. So I don't have specifics on that, but that is an addition to what we've been talking about. So we may end up in a situation where we have the potential for a quiet zone through virtually the entire county. So what we have before you, I believe many of the members here who sit on city councils and the county commission have had this item before you as part of your municipal council action. So I'm not going to go through all the background and justification of it. The members in the package, and you may have discussed it some at your respective board meetings. So if there are any questions, I'll be happy to answer them. But as it now stands, the resolution is before you. And we do have unanimous support from the affected jurisdictions to participate with TPO in coordinating the effort. One final thing I do want to add is the Federal Railway Administration will not allow the TPO to be the applicant. We have no official legal jurisdiction over any grade crossing. So the applicant actually has to be one of the local governments with jurisdiction. And we need an entity to be the lead. That doesn't require any additional work on anyone's part, but there has to be a lead, and then all of the other jurisdictions can piggyback on that lead application to file a joint application. So we will be seeking one of the jurisdictions to serve as the lead agency for the application. That would also apply for any matching funds we may be seeking from the state of Florida.
Mr. Chairman, yes, I'd like to, I spoke with Jenny Lamb, our Director of Engineering, and we don't see a problem for us to volunteer to be that lead agency. Since we have the most crossings. Okay.
Thank you very much.
Any questions for Bob? Any comments? Chairman, then entertain a motion to approve resolution 15-12.
Mr. Chairman, I move for approval.
Deputy again. Councilman Green, second. Discussion. All in favor say aye. Aye.
I want to thank you all. This came together very quickly. I am particularly proud of the way we've been able to do this. This is, to me, a perfect function for TPO. I don't think anybody else could have done this. It would have been each city for themselves. It would have been a hodgepodge of things. So we do have a limited window of opportunity here. So I'm very pleased that we've been all able to work together and get this far in getting a coordinated effort. I think the community will benefit in the long run.
Maybe I should have asked, are there any speaker cards on any of these? Does anybody sign? See no movement, okay. I don't want to leave any speaker and memo not being able to express their opinion. Action items 6B, approving, directing staff to draft a resolution regarding amending grade crossing agreements to add Oliver, Florida. My understanding is that Commissioner Infantini is the one that asked for this to be on the agenda, so I would ask if she would like to explain it. You know, the next three items are on the agenda as a result of the request of Commissioner Infantini, and you know, the actions to be taken. Certainly, you know, I can say I can vote one way or the other on those because the Canal Port Authority has passed a resolution supporting all of North Florida. Some of these issues may be something that you want to take back to your respective commissions to discuss to get direction as to which way, depending on the explanations from Commissioner Infantini, how you want to vote on this. Commissioner Infantini, you now have the floor.
Thank you.
Yeah.
First, I'd like to say I hope everybody recognizes that the TPO, as Bob Crom had previously explained with the quiet zones, they lack any jurisdiction on any of these action items. This is merely a support for, in favor or against the things that I will be mentioning. So I realized we have no legal jurisdiction. I was presenting it to our county commission, and they said bring it to the TPO. Well, when I bring it to the TPO, they say, well, we don't have jurisdiction. So you can see where I'm in a bit of a loop. Okay, so I'm trying to do what our commission asked, and so as such, that's why I'm bringing it forward to you. I'd like to thank Bob Com for helping draft the wording on that. It was greatly appreciated. You worked with my staff and handled that. There's three items, and I'll kind of count them, put them all together. One of them, Indian River County has already passed a resolution which says that they do not want to substitute All Aboard Florida with Florida East Coast Railway as having the lease agreement. They want our lease agreement for the grade crossings to remain between the county or each municipality and Florida East Coast Railway rather than substituting them. And part of it is because of the collateral and things like that. The next item is for asking that as a TPO, we pass a resolution, again, knowing we have no legal jurisdiction, but we have a voice. And it's saying that we do not want federal funds going to support Florida, All Aboard Florida. If this is a profitable venture, like Southwest Airlines or UPS, then investors will clamor to invest their money in this project. If it's not profitable, well, then you see people coming to the government asking for low-interest loans or tax-free interest loans. So for that reason, I'm asking you to support the resolution 6C. And then finally, 6D. 6D asks, like Representative Posey had asked, that the government really look over the loan application being submitted to the federal government. Right now, All Aboard Florida is asking for roughly, I think, $1.75 billion. They're saying that some of that they will not ask for all of that 1.75 in exchange for getting tax-free loans by using Brevard County. But what happens is, if they would look at the loan package thoroughly, they would see that there are no passenger rail services that are profitable. One such review of a loan application from a company out in California. They were going to run a rail line between California, I think it was San Francisco and Las Vegas. They pulled the application because they turned it down because they realized there's no way that passenger rail is going to be profitable. And so it was not a good venture. I really want this board to support that we will have All Aboard Florida, instead of running their freight along the densely populated coastal regions, instead they'll have their freight run through the center part of the state where it isn't densely populated, where the trains will not interfere with the travel from east to west and west to east. And so that's pretty much what all three of them are about.
Certainly, I would say, speaking from maybe a viewpoint of the Canaveral Port Authority, I don't know that we would really like all the freight going through the center of the state, since we're trying to drastically increase our cargo business and hope that there's a shorter distance between the port and when they can get on some railroad cars running. But I understand what you're saying. And I might say, you know, I agree, and what Bob has said is that we as an organization do not really have what I would call standing to make those presentations, but don't we as members of this organization have the voice of the entity that we represent, and shouldn't that entity that we represent give us direction as to what actions we should take one way or the other with regard to all aboard Florida and those specific things?
Well, I would have thought so, except for when I took it to my board. My board said, come to this board. So apparently my board doesn't feel comfortable with making a decision without coming here first. So I backed up, I come here first, and now you can send me back, and then I'll go back to them and tell them, hey guys, I went, they said go back, and so now I'll go back again. I don't mind the ping pong game, but I'm
Maybe the Canaveral Port Authority is a little more forward thinking, and we made a stand, and we passed a resolution where we stand on the issue, and not that we stand alone in all of this, but certainly I know what the Canaveral Port Authority's position will be on anything relating to all aboard Florida. Discussion.
Mr. Chairman?
Mary?
Yeah, first of all, I can't support this because our board, our city council hasn't even addressed this. So I would like to take it back to our city council and one way or another, and we'll have a discussion on this. So that's why I can't support it.
oh, that's fine. I understand. I completely understand the position. I would have loved to do it first at the board level, but
You're just following what your board directed you to do,
That's right.
which is good. That's good.
Mr. Chairman?
I saw Commissioner Fisher's hand, and I'll come back down to one. Commissioner Fisher.
Yeah, I think each commissioner probably has their own feeling on this issue, and my position has kind of been that I want to make sure that we're supportive of all of Florida, that we get the best we can for the Florida County. And there's some negotiations that I've been involved in, at least I've expressed my feelings on the issue of what I would like to see happen for me to be supportive. And there's a lot of things in the Commission Continuing Resolution that actually contradicts some of the things that I'm working on. One would be in a lot of conversation with your organization, John Walsh and the court. The other would be, and it's probably public knowledge that all of what Florida has taken a position that from a zero cost of maintenance that we only presented a 7-year cost of maintenance to our board. This resolution here says that the county will bear cost of maintenance. I'm contradictory. I don't want us to bear cost of maintenance. We'll have to, and their representatives know that I'm pushing in a certain area, certain things. So I think from the standpoint of transferring the ownership of all of it's very typical in any corporation. They always want to have the right to make assignability to somebody else that they're going to sell or not sell, and they want those types of new corporations take the liability accountability. So I don't think that's a fully goes all for at the end of the day. It's all probably money. So I think the resolutions are not very well written or thought out, and we want to be careful about us supporting something. Because what it means when we support it is that that's a position we're taking on something. Now, and I'm not taking a position for maintenance and those things today. So I'll totally support it. And I don't think the county commission is going to come back and do much with it either. So we'll move forward.
Okay. Commissioner
Yes, thank you. I've had some probably off-site communications with all aboard Florida. Item 6D, supporting Representative Posey's request for the GAO review. I believe it was Monday or Tuesday of this week. It was Monday, because the article came out Tuesday morning's paper. Rusty Roberts, who's been before this group, explained to me that all aboard Florida was stepping away from the RIF loan. They were going with private funding. So 6D is going to become a moot point if that goes on. So 6D is completely moot at this point.
And I would agree with Mayor Behan that it's gonna take some time for me to get this back to my city council. My agenda for next week has already been posted, it can't be amended, won't be amended. So it'll be at least first meeting in November before I've had an opportunity with my city council to let them look at this. Again, I'm their rep here, it's not my choice, and I really struggle with the timelines between the two meetings.
Well, I do have, you know, it was an accommodation really to Commissioner Meeting. She wanted to
Oh,
have the agenda,
no
and
problem with that.
certainly, the staff wanted to be accommodating to that.
Can I put that one more thing?
Sure.
We do have Mr. Moore in the room, he was somewhat representative of all of the, I've had communication with him as well. On certain issues. If we have any direct questions, we might go and pose them to him. I don't know if he's prepared to answer them, I didn't know he was coming, so I'm.
Well, we can.
I think he'd rather just sit quiet.
Yeah.
He's always gonna get hot, get out.
Mr. Chairman, I'm available if needed, but that'd be at your request.
Okay.
I too spoke with Mr. Moore. Actually, I spoke with him day before yesterday regarding the RIF loan. And I asked, did in fact he pull back, did they pull back and withdraw their application? They have not. And so oftentimes people will make a comment that they're planning to do something. So until they actually do something, it isn't so. And so I can have a lot of plans, but until they actually put it in writing that they are withdrawing their loan and will not seek federal assistance, then it doesn't actually make it so. It makes it a plan, and a good plan, and one that I support, because then you'll go out to private enterprise. So this actually does have a bearing on here until such loan with application has been withdrawn. So I wanted to comment about that. And then I believe that they are not seeking 1.75 billion withdrawal. They were only going to withdraw a portion of that loan application, not all of it. So I just wanted to clarify, because sometimes there's parts of information that get out there, and if you haven't had an opportunity to really look into something, you have enough that it's not full. And with regards to the resolution that Commissioner Fisher was talking about, what it's stating is currently we do maintain the rail crossings, and when this was written, we were still maintaining them. And when I see in writing that All Aboard Florida has agreed that they will, I have not seen it. I haven't passed a resolution saying or accepting it, but if they will give me something in writing saying that they are going to take ownership of full maintenance and responsibility for the grade crossings, that would be wonderful, and I could take that part out of the resolution.
Okay, Tony?
I have a quick question. There's a statement in here, at least for the item we're on, 6B, it says the requested action is to direct the attorney to draft a resolution requesting all TPO member governments to oppose adding All Aboard Florida as a third-party beneficiary. Could the attorney explain to us what that means, adding them as a third-party beneficiary?
I'll try. I'll tell you that I have done a fair amount of research on this grade crossing agreement situation on behalf of the city of Melbourne, which is Mayor Behan pointed out. They've got 22 crossings, which is a pretty high number for any local government, any municipal local government. And the agreements, for the most part, are all very old. They were generally penned back in the 1960s, 1970s. There are some that are a little bit more recent. And the agreements are between the FEC and whatever governmental entity has jurisdiction over the grade crossing. In other words, if you're talking about US 192, the agreement is between the FEC and FDOT, the state of Florida. If you're talking about a local street, then it's between whoever has jurisdiction over the local street. In my case, in my research, to the city of Melbourne. And then there are some grade crossings that are within municipalities that are letter was supposed to be signed by the local government, all aboard Florida, and the FEC. And what it would do is it would add all aboard Florida, which is a separate legal entity. It would add them, in a sense, and I'll tell you what in a sense means in a minute, as a party to each individual grade crossing agreement. And there's an individual grade crossing agreement for just about all of the grade crossings. The terminology in that letter is that they would be a third-party beneficiary. And what that means is that the grade crossing agreement is for the benefit of the two parties to the agreement, plus all aboard Florida. And it would be recognized by all three parties entering into this letter of agreement that in fact all aboard Florida was a specifically intended beneficiary. And it's pretty close to having party status to the contract. The question, I talked with a number of local government attorneys. I talked with the county attorney down in Martin County, the county attorney in Kingwood County. I had a number of conversations with the county attorney here, Scott Knox, and also talked with the Palm Bay City attorney. And all of us kind of looked at this and kind of scratched our head, and we're trying to get a handle on this third-party beneficiary status. It's a little bit illusory, but I think the easiest way to look at it is that they're actually becoming another party to the contract, that they may not have every single right that's in the contract.
Is it necessary for all aboard Florida to have that status in order for them to step up and negotiate or assume some portion of the maintenance responsibility for those crossings?
Probably not. If all aboard Florida was to assume maintenance responsibilities, they could probably enter into some sort of arrangement with each individual local government where they would maybe donate some monies, and the local government could then pay their contractually required share of maintenance to FEC. I mean, there's a number of different ways that it could be done, and why all aboard Florida chose this vehicle, I don't know. I will tell you that initially I had a number of conversations with one of the attorneys from all aboard Florida. They were helpful in getting us some information, and then it's kind of like everything went silent. We weren't having good communications. What happened exactly, I don't know. So I think that there's a lot of unanswered questions.
So as far as we know, all aboard Florida has requested this, to have this third beneficiary status, but we don't know why they've requested it.
Well, I think I can speculate. It's just that speculation. I think that by doing this, they're going to have some ability to have control over the grade crossings. And if you think about it, it makes, put yourself in their shoes, it makes some logical sense, because as proposed, their trains are going to be crossing these grade crossings numerous times each day. And and I'm assuming that they have some separate agreement with FEC with regard to using FEC's tracks. They would have to have, otherwise.
So I guess my final question then is, Mr. Chairman, given the lack of data and the speculation and what we don't know about
Difference of legal opinion.
all of this, perhaps Commissioner could explain to us why we ought to be opposed to this, given all the uncertainty that we've heard.
Commissioner, I think there's another question that I've been receiving is, what are the consequences of not authorizing the agreement as in the county position? What are the consequences of that? And approving the addition of Alva, Florida, are we jeopardizing other benefits that we may desire? Or in general, what are the consequences? I've not heard that question. I've heard the question asked, and I don't know the answer to the consequences.
Mr. Chairman.
Paul has his legal calculation.
I would think that they want, and I know nothing about these agreements, but just reading the words, I would think all of Florida wants to be at the table to negotiate these upgrades, that they want to have a say as opposed to standing back in the corner saying, oh, we want to do this, we want to do that. If they're going to be actively involved in paying the cost of upgrading the crossings, I would think that they need to be a party. I would think they would want to be a party. But, hey, there's a lot of unknowns, so it would be somewhat questionable as a collective group of us voting on something that maybe we have more questions than we have answers to.
Well, I thought it was coming back to me after you asked the
Oh,
question.
okay, well, we'll come back.
Oh, okay. And so, like Mr. Khan explained, if they're required to make safety upgrades in order to facilitate the transfer, trains moving at such high speeds, well, required is the operative word. If they're required to do it in order to operate trains going at that speed, then they're required to do it. What I'm trying to do is not relinquish my rights to the rail lines and turn over permissions that are only granted to FEC, grant those exact same permissions over to all aboard Florida. And as you have all mentioned, there are differing legal opinions, and a legal opinion is just that. Many of us have opinions, but until it goes to a court of law, an opinion is just that. So it would have to be tested and tried in the court of law. Because all of us could speculate and we could hire any number of attorneys and each one of them come up with a different opinion. It doesn't make it so until it's been ruled upon, until it's been tested. So I would say that we should follow the lead of Indian River County and say that we do not want to relinquish our rights to all aboard Florida and let them take that to a court of law and test it. Because until then, we really don't know what that means.
Thank you, Chairman. I'm kind of a little bit of a crossroads on this because I have publicly said that I do not support the all-aboard Florida rail. But at the same time, I'm elected to represent Melbourne. And the crux to my problem is that by asking all-aboard rail to enter into the contract, they are asking for value. And I want to know what value they are giving me as a city in exchange for adding them. And we have not been told as a city entity what that may be, if anything. And so, while I agree with you in principle, I am giving you more value and you're not bringing anything to the table for my municipality. I can't today sit and vote with you only because we as a city council, Mayor Meehan is right, we have not talked about that. And so, while I appreciate what you're trying to do, I think the body that I represent has to have that discussion first before I can go forward.
Well, I've given you, I've already turned that one over and said, I completely agree. I only brought it forward to this board because I was asked to. Otherwise, I would have gladly. But as far as value, what I would like to get from all aboard Florida is something in writing, guaranteeing, like Commissioner Fisher had alluded to. They said that they would do something for maintain for 7 years. Well, I would like to have all of this in writing because until it's in writing, it's not a legally binding agreement. So what are you going to give me for transferring ownership? I want something legally binding that you're going to give me in exchange for me giving you subrogating my rights on that railway.
I agree.
We're giving away something, we're not getting something back in writing. We're getting, well, we hope, we plan to. That is nothing without being reduced to writing.
And I agree with you, Commissioner, and that's kind of where I'm at the moment is I'm not willing to take this step, but I'm willing to go out and say that I expect value in exchange. And until I get that value in exchange, I will be opposed. So, but, thank you, Commissioner Fisher.
So I think what we did in the last
I was just going back to say, I believe it was back in, it was before August, it may have been
Was there a vote?
July.
Was there a vote?
Oh, okay, would you like to give me on semantics? You said you would not go forward, and it may not have been voted. I apologize if I misled anybody here to say it was actually voted on by the county commissioners when instead it was requested. Excuse me.
Informal
Sorry.
decision on that part
I
for you.
apologize. I would never intentionally mislead you.
I think the county commission has had this issue before us on numerous occasions. We've been waiting for a report from our attorney. It's been continued on several occasions because there have been no real discussions about it, and we're still waiting for that. So certainly, I would say that, as Commissioner Fisher has indicated, that we're waiting to get all of the facts on the table. Our board has taken the position that as a majority, we want to know all the elements that are part of this discussion, so that when we make a decision, it's based on all the facts and not take individual items one by one. So we're still waiting for that information. There will be some point in the future where all that's available and the commission will make that decision.
To clarify the point, it was in late April when the commission requested an item be brought to the TPO, and at the May TPO meeting, we had it on the agenda. You may recall we had many residents in the audience who spoke at the May meeting.
But I don't think it was related to a specific part.
I can't recall, I don't believe it was the specific items, but it was about all before.
Right,
More
it was,
general.
I think, I want to say May 13th, somewhere around then, that I brought a resolution to not support all aboard Florida and the subrogation of the loans, but that's fine. We'll go ahead and take it back to our
As I
boards, and
recall,
thank you
Chair
very much
moved
for
that
your
motion,
indulgence.
and Chair moved that motion was out of order because it wasn't on the agenda.
Right.
And now you brought it forward, so.
Thank you.
So, Commissioner Green.
We all agreed to have the first resolution approved because we did research, but we were put under the gun for a time that it had to be done because their company was applying for permits or whatever they needed to get. All my question is, and I'm sensing a consensus that we don't have enough valid information, and our council that we represent doesn't have, we don't have the consensus of our council while we're sitting here. Is the possibility that we could be put under the gun again for a time span for a decision to be rendered by us, by the company, or by the system?
The answer to that is yes. I will tell you that when the letter, the draft letter that I mentioned earlier came out early this year, it was unsigned, and in the letter it talked about, this is a one-time offer, you have 60 days, and I kind of looked at it and I thought, well, 60 days from when? When FEC Railroad actually signs it, or what? And fast forward to, I don't know, sometime over the summer, County Attorney Knox, the county engineer, the Melbourne City engineer, and I had a meeting with the All Aboard Florida, their new general counsel, Mr. Tobin. And he was a little shocked to hear that that was out there, and apparently somebody on behalf of All Aboard Florida had circulated to some individuals that they were under the gun. I never felt that Melbourne was, I can tell you. And Mr. Tobin's comment was, well, we don't want to put you all under the gun. That's not a good way to negotiate a solution or negotiate the terms of this letter or anything else. And so we need to make sure that that's not the case, and we'll get something out to you. Well, getting something out, I never got whatever it was that they were going to send, but then again, I never really felt that we were under the gun. But the bottom line answer to your question is yes. If they chose to, they could send out a letter and saying, you got 60 days, the clock's ticking. I don't think that that's very helpful to their cause. But again, people do things sometimes that for strange reasons.
Would you just had said prior that you asked a group of attorneys their opinion, and now all of a sudden the information flow isn't coming back. You requested some information, and the information isn't coming back to you or to the
Well,
group.
and that could be for, and I'm talking about all of Board of Florida, and that could be for a number of reasons. It could be that they've decided that only one person legally with their organization should be sending out legal statements. It could also be that about this time, all of Board of Florida was in the process of bringing in a new general counsel. Or it could be some negotiating posture. I honestly don't know. And to me, ultimately, in the end, it really doesn't matter because we'll just push ahead and do what we think's in our own interest.
Because I have a serious problem with all the questions that were asked and all the uncertainty and lines of communications that aren't existing right now. I have, and that's just my opinion, because there's 4 other people on council. I'm having a tough problem taking a pig in a poke on this one, in all honesty. It's just, it's a shot in the dark, and that's a nice way of saying it. So I'm myself as Bombay, and I'll bring this information back to council. I can't support this.
May I offer a suggestion? I don't know what the body here intends to do, but some of you have talked about delaying further discussion on this until you get guidance from your own respective governing body. If you decide to bring it back in whatever form here for further discussion, there have been a couple of questions that have been asked here today that I think are good questions, and that is, why does all of Board of Florida want everybody to sign this agreement? May I see, and certainly in deference to Mr. Moore, who's here representing, it might be interesting to invite their general counsel, Mr. Tobin, to come up here. He's had 30 years of experience in the railroad industry before he came down here from Chicago. Obviously, an intelligent guy with a good background, and he may be able to shed a little different light on things and at least give you their perspective. May not be the right answer for where you want to go or what you want to do, but at least you have some understanding directly from them as to what their posture is on it.
And like I said, we do have one speaker card that has been signed, so any other comments from any of the members of the board before I have the speaker comments? Monique Miller.
Good morning. Thank you, Commissioner Infantini, for bringing this to everybody's attention, because this is an important point, and it's sort of one of the consistencies with all of Board of Florida and their plans is that there has not been a great deal of clarity in any forum, and I think that this is probably the most appropriate forum for these discussions, and obviously everybody will need to go back to their own groups to get answers at the individual municipality level, but I think these are the important questions that we should be asking. And thank you, Mr. Bigelman, for your efforts to uncover one of the most important questions of all, and that is, why would a company, a private company, be pushing all of us to be doing this in the first place? Doesn't make a lot of sense. Is it important to them to perhaps separate one company from the other, so if something happens to one, the other is protected? That is certainly one of the possibilities. I wanted to bring to your attention that I think it came up, but it's important to everybody to know that we do not know which federally subsidized means of funding this they are going to use. They have not pulled the request, the RIF loan, and now they're pursuing another loan option. It's actually an issuance of private bonds, which are subsidized by being tax-free. It's, again, still a taxpayer investment, and I don't know that I want to make this investment based on the information that I've heard so far today. It's obviously going to be a devastating thing to our community. It could be a positive thing, but the problem is we don't know. Now, you'll have to forgive me, I come from the private sector. In the private sector, when we negotiate a contract with somebody, we sit down and we look at all of the values on one side and all of the concessions and values on the other side before we make any decisions. So before we make any signatures and
picture and all have extreme clarity on what it is that we as a community are getting from this and what we're giving away.
One more minute.
Oh, no, that's really, that really comes to it. The one last thing that I wanted to add is, there's also some discussions about Amtrak. And one of the questions that I have that's an important question is, this is a company that has never, ever, ever done anything in passenger rail before. I know there's some discussions with Amtrak. Is it possible that they are looking to lease that business or outsource that business to Amtrak? And if that is something that they're going to do, that's an entirely different financial business for us to be looking at, and the future of that would certainly be highly suspect. And so that's something else that I think we need to understand before making any decisions.
Okay, thank you very much.
Thank you.
And the next speaker is Kendall T. Moore, attorney extraordinary, representative of a
Good morning, Mr. Chairman, members of the TPO. Kendall Moore here this morning, representing all over Florida. I do apologize for somewhat delaying to listen to the opportunity to hear from both what everyone on the board had to say, as well as concerns that other speakers may have. Let me suggest to you one thing. Certainly, Mr. Googleman has talked about the nature that there was not a totality of every piece of information from the beginning. And I think everyone would agree that this is a large, substantially complicated transportation project, that there is not a definitive model out there in Florida that you look to and say, you know what, it's going to go exactly this way. And so if it seems to take a little while, the information flow seems to be a little bit difficult at times, it's a very complicated process, and every single day this project does morph in a variety of ways. But I think, for our purposes today, let me talk about the three specific things that are here relating to the resolutions that you have before you. Number one, I think the quiet zone issue that you dealt with first makes sense relative to the best position and opportunity to take with the All Aboard Florida project. And that is, we strongly believe you get the best benefit for both the parties of government and All Aboard Florida through the process of facilitation and negotiation, not through the process of we're going to hunker down, knock down, drag out, fight, and kind of see what comes out of this for the best possibility. There was an opportunity for a quiet zone. All Aboard Florida could not apply, but All Aboard Florida did come forward and share with each of the governments that were going to be impacted that you had the opportunity to apply for that quiet zone that would be beneficial to your residents. All Aboard Florida could not do it. The government had to do it and had to apply to the Federal Railroad Administration in order to get that opportunity. All of the impacted cities, as well as the county commission, did pass resolutions to authorize the TPO to move forward in that process. Let me fast forward to what's there today and what was referenced that's upcoming. There have been discussions about maintenance agreements, and there have been discussions about the ongoing crossing agreements. As of yesterday, there was an agenda item that was submitted to the Brevard County Commission that speaks specifically to the new financing strategy that was referenced by Commissioner Infantini and others in terms of private activity bonds. Doing a little bit more research on that, you will clearly see that that is a financing strategy that we did hear, what Commissioner Infantini and others referenced, that poses no financial risk to the local, state, or federal governments. But more specifically, it also addresses in detail the company's willingness to make a financial contribution towards the future maintenance for both the county and the cities along the corridor. I don't have the time, obviously, because in 5 seconds your chairman will tell me that I'm out of time. But those details specifically are there and available for you to see that will benefit both the county and the cities. In the shortest answer possible to Mr. Googleman's question, All Aboard Florida today, or should I say FEC actually has the rights today, if there was a decision tomorrow to go and upgrade a crossing, they could upgrade it. The city or county responsible entity would be responsible for paying for that upgrade and would be responsible for paying for the maintenance, as has been the case for decades.
Thank you, Mr. Chairman. Mr. Moore.
I was hoping somebody, one of your members would ask me to keep going, Mr. Chairman, but I'll yield to your time.
Mr. Chairman.
Can I make a motion that he can extend his time?
Okay.
Second.
Discussion. All in favor, say aye.
Aye.
But I didn't want to give him any more leeway than any other
I'll just make it as brief as possible, Mr. Chairman, but ultimately, if an upgrade was done at an intersection today, as has been, at a crossing today, as has been the case for decades, as it exists today, the county or city or responsible entity for that crossing would be responsible to pay for the upgrade itself, the construction of that, as well as the ongoing maintenance. It has been the case in the agreements that your government entities have had with the railroad for decades. The two factors that are different, number one, and this has been said a long time ago, so it's somewhat been lost. All Aboard Florida has a desire to be a part of the crossing agreements because they are paying for the upgrades to each individual intersection, which as of today, they are not required to do as a part of your existing agreements. So that would be number one. They are a party who is paying for that upgrade. The second thing that you will see in that agenda item is a suggestion that both at the city and county level, a willingness on all Aboard Florida's behalf to make a contribution to a specified number of years of maintenance as a part of this particular process associated with the private activity bond funding. And final to Commissioner Infantini's question relative to that, we certainly have listened to everyone and made an attempt to talk to everyone that would talk to us because we believe that negotiation and facilitation as opposed to fighting is going to be the best for everyone. For all Aboard Florida as a private entity and as well as for your government. And so as it relates to the RIF loan versus the private activity bond, I think for anyone who is doing a financing transaction, if you've been traveling down one road and you are investigating the opportunity of another, you are very, very hard pressed to back up and say, I'm going to give up this one before the second one has ever been publicly considered by the entities that must agree to that. Mr. Chairman, I did hear what Mr. Googleman said and others relative to Miles Tobin, and I'm sure that the company would be willing to make their general counsel or anyone available that may be required. But I'm sure as of the agenda item submitted on yesterday, there will be quite a bit of questions, discussions, and others to answer many of the questions that have come up today.
I have a quick question for Mr. Moore. You said that we would be responsible, Brevard County or the municipalities would be responsible to pay for the upgrades to the existing track. If they were going to run a high-speed rail, we have to pay to upgrade the track so they can run a high-speed rail. Did I understand that correct? Because I'm sorry, I didn't.
And let me clarify, I think that'd probably be a question for Mr. Googleman. Currently, the county and the other cities have an agreement with the railroad. And your current agreement with the railroad, most of them, I think Mr. Googleman said previously, are somewhere in the neighborhood of 50, 60, or 70 years old for the majority of the agreements. As they currently exist today, when there is an upgrade that is necessary at a particular crossing, that is something that you pay for on that upgrade, and you are, as of today, and have been for decades, responsible for the ongoing maintenance. And so that is as it said. So if there was a desire to go in tomorrow and to upgrade or replace a particular crossing, the status of the agreement as it exists today, you are currently financially responsible for that. Now, I'll defer to Mr. Googleman. I mean, he knows that particular issue as it relates to you. There are many lawyers in this room, but I'm not the one here advising the TPO or commissioners relative to that.
Well, Mr. Chairman, I think Mr. Moore is exactly right. Each of these agreements, they were all penned at different times, so it's not like it's a form agreement that's used for every grade crossing. They're all slightly different. But the common thread that runs throughout them is that, as Mr. Moore pointed out, if there's going to be any upgrades, if there's going to be any improvements to a grade crossing, not the system, but to a particular grade crossing, the local government is liable. And as a result, what does that include? What does that mean exactly? Well, the agreements are not models of clarity, but I think there's an argument out there that the laying new track at a grade crossing could be an improvement that a local government might be responsible for.
But is that, FEC doesn't need new upgrades to their track to do what they're currently doing. And FEC is not going to be running a high-speed rail. It's AAF, and AAF doesn't have the lease agreement with us. So why do I have to, and I'm just missing, because if I've misunderstood something, I'll so they can run their high-speed rail. And they don't own the rail or have the lease. Why do I have to do the upgrades? It's FEC that we have the agreement with, and they're not running the high-speed rail, and their trains run just dandy.
Well, the letter agreement that was sent out earlier this year, and that's a good point that you raised. The letter agreement that came out this year, that if signed by AAF, FEC, and the affected local government, indicated that AAF would agree to pay for all of the upgrades except for quiet zone. And in return for that, they would be granted third-party beneficiary status. And that was, at least that was their presentation.
Are you aware that it would possibly FEC have the right to sign their rights and ownership to FAA for money?
I would not be the least bit surprised to find that there would be some agreement between AAF and the FEC Railroad for this entire project. And I don't find that particularly mysterious or clandestine, but if you think about it, most of the FEC system is a system that local governments really don't have any involvement with. It's basically something that's under the control of FEC, and I would think if AAF is going to be running a regular service over their tracks, they would probably have to enter into some sort of an agreement with FEC. So I'm sure that there's something out there.
Probably there would be no prohibition to that in the existing agreement, because I'm sure 30, 40, 50, 60, 100 years ago, there was never any thought of any other use of the existing lines other than what FEC was going to do at the time.
Yeah, it's whatever Henry Flagler wanted.
Thank you, Mr. Chairman, for the additional time.
Mr. Moore, can I ask you one question?
Yes, sir, Mr. Green.
You said that they were going to make a contribution to help offset costs for some of the cities. Is that in negotiation too, or is that a set amount at 25% or 40%, 50% of? Right now, we got a bill of $114,000 to maintain a crossing. So somewhere in our notes here, it said it would double. So is it the pot that doubles, are you going to be paying a contribution or the whole crossing itself?
Let me address two things. One, it's in terms of the number of years as opposed to amount. And as I mean, Mr. Dinghoff here earlier, there's been some spirited debate as to what the maintenance delta is. There was an original assessment of 2x, there was an assessment of 1%, and I think that the convenient figure being used now is 20% or something less than that. What does that mean? If there were an upgrade, that the new level of technology with the equipment ultimately is more expensive than the equipment that's in the ground today. The proposal that was submitted yesterday was in a number of years, is actually a county commission agenda item, but the benefit to the county was one that we agreed would be in the best interest to offer to the cities as well. I think the count is 42 crossings countywide, of which only 17, I think, are under the county's jurisdiction. I think Mayor Meehan spoke earlier that Melbourne has more than any others, but the offer on the table was a 7-year maintenance guarantee. In other words, that the city and the county, cities and the county would not be responsible for maintenance for a 7-year period from the upgrades. So that's what was submitted as a part of the agenda item, and that's a matter of public record as of yesterday, an agenda item. And I'm sure that you've not seen it yet, but as soon as you do, I'm sure that we will hear from all of you with a desire to hear the details of that and better understand. But it specifically is a 7-year maintenance guarantee for both the cities that are involved as well as the county.
Thank you, Mr. Moore.
Thank you, Mr. Chairman.
Mr. Chairman, so when you look at resolution 1513, for example, the second to the last paragraph, where local government will bear the maintenance cost of upgrade railroad crossing in the cost of installing and maintaining quiet zone 50 railroads, here we have a county commission item that's coming before us, saying that on the paper, they're offering 7 years of maintenance, and then also, they're offering quiet zones, and our resolution here that's being asked for board support is in contradictory of them paying for it, which doesn't make sense to the taxpayers or any of us. So, they're offering to pay for quiet zones, they're offering to pay these 7 years of maintenance, that will be looked at. But here we'll be passing a resolution saying that the cities and government prepare that, local government prepare that. I don't know why we want to do that, sir.
Commissioner Diggy, do you want to make a motion regarding these, or do you want to?
I would like to make a motion to hold off on these because I'm very happy to see how Olive Ward, Florida is now stepping up to the plate a little bit more with what they offered, because prior to all of these things being on the agenda, I have not seen anything in writing. I still haven't seen anything in writing, but it doesn't mean it doesn't now exist. And if through
You
this,
just want to withdraw those items?
I would like to withdraw those pending the outcome of the new negotiations with Olive Ward, Florida, and additional information. And I thank you.
Since they're your agenda items, we will remove them. Thank you.
Great.
Which items are you withdrawing?
6, B, C, and D. The 3 items that were working here by Mr. Item 6, E, approval of legislative agenda. Steve Hope.
Good morning. The proposed legislative agenda is on pages 42 and 43. We're pretty early right now, but we probably will not see you all again until December. And many of your jurisdictions are already working on your legislative agenda. And we wanted to make sure that you have the opportunity to include some transportation items in your own legislative agendas. This is very similar to what we have had in the past. There's only one new item at the top of page 43, which is to fund the Transportation Regional Incentive Program, the TRIP program. That is the money, the color of money that was used to fund Barnes Boulevard, the construction and widening of Barnes Boulevard. The funds come from the documentary stamps. As you know, the Water and Land Conservation Amendment is on the ballot in November. It will also draw from documentary stamps. And so we just want to put out there the Water and Land Legacy passes and certain documentary stamp funds are set aside for that. Don't forget about the TRIP program. This is an important program for local jurisdictions to fund their projects. So we just want to have it on here as part of our agenda. So that's the only addition.
I'd also like to call members' attention to the fact that the delegation meeting has been set for December 18th, which will be Monday. Well, whatever day it is, it'll down in the
Thursday,
December 18th.
Any questions for me? The chair would entertain a motion then to approve the draft. Oh, are you going to come back? And this is your draft, when are you going to come back?
It's likely we'll have, once we're past the election and folks start filing bills, it's likely we'll have some additions in December, but we want to start with it.
Okay, the chair would entertain a motion to approve the draft legislative priorities.
So moved.
Tony, second. Discussion? All in favor, say aye.
Aye.
Opposed? Okay.
Thank you.
Thank you. Reports and presentations. Item A, US 192 intersection design alternatives. Carl is going to give us that. Welcome, Carl.
Good morning, and thanks for the opportunity to present on our study. We've presented on this study a few previous times, and now we want to come back with an update of where we are. The agenda this morning, then we'll just go through the overall feasibility study, and we'll talk about how we got to the Wickham Road and Hollywood Boulevard concepts and explain those concepts and the steps moving forward. So the US 192 feasibility study was a project that we worked on from November of 2011 to October of 2012. This project looked at the feasibility of widening US 192 from 4 to 6 lanes from I-95 to Babcock Street. We looked at the traffic operations, the safety, drainage and right-of-way, developed concepts, and also costs. The recommendations from that study were, instead of looking at widening 192 from 4 to 6 lanes, we wanted to focus on the funding of the Ellis Road improvements. That's a study that's been very important and a priority to the TPO and is working its way really on the goal line to getting approval. So we also identified that there are some short-term needs on 192 that we could satisfy, and those were focused on the Wickham Road and Hollywood Boulevard, the number 4 and 14 busiest intersections according to our State of the System report. And after the Ellis Road improvements are put in, after these intersection improvements are put in, we would then come back and reassess the traffic on 192 to see how patterns have changed and if there are concepts that could move forward. So the background of the study, it really follows the FDOT corridor planning guidance. We started with the feasibility study. Alternatives for improvements from a planning perspective were identified. Those are the Wickham Road and Hollywood Boulevard intersection improvements. Those concepts are further developed, and we seek approval from DOT on those concepts to then move into the design phase. There is funding for the design phase that's been identified in fiscal year 18. And then based upon the design phase, there is not construction funding that's currently identified. So in terms of the coordination on these projects, there's been a lot of it. Projects like this overlap a lot of different DOT offices. So starting with traffic ops and design, understanding the traffic patterns and the design challenges that come with it. The right-of-way office, getting the costs for the right-of-way that would be needed for the project. The long-range estimates, understanding the construction costs. And then the systems development office, making sure that as this project moves forward from planning to design, that it's a good project. We've also held many meetings with the City of West Melbourne. They've been an active and supportive partner. We've had a lot of discussions with the county, so the county is aware of these projects, and as well as the TPO staff has been really a driving force all the way back from the initial feasibility study to getting these projects out of planning and into design. So the first project that we want to talk about is the Wickham Road intersection. This intersection has a very high volume with the 55,700, again, fourth highest in the county. The volume on Wickham Road also contributes to delays along US 192. That's the allocation of the green time of the traffic signal. The more time you have to give Wickham Road, the less time that you have available at US 192. So that's how that works. The eastbound and southbound approaches do not have exclusive right turns, right turn lanes, nor do the northbound or southbound have dual left turn lanes. And looking at the constraints of the intersection, they're significant. If these were easy projects, they would have been done a long time ago. So there shouldn't be a surprise. There's no right of way that's available on the north leg. The choices that you get into are utilities on one side or Walgreens parking on the other if you're going to work on alternatives with that north leg. So those are significant impacts that we looked at. The different concepts that we studied, the first concept was just an eastbound right turn lane. The next concept was the eastbound right turn lane and the northbound left turn lane. And then we looked at a range of concepts that provided, in addition to concept 1 and 2, the southbound left turn lane and the southbound right turn lane. They're different concepts because it depends on which way you shift them within the roadway. There's some different impacts that come with that. So in selecting a preferred alternative for this location, there were 3 concepts that were dropped due to a low benefit cost ratio, which really has a fancy way of saying that the high costs for the right of way on that north leg, the benefits that we received just didn't really justify those high costs. For concepts 1 and 2, we did see some comparable operational benefits. We chose concept 2 because it allows us to construct the 2 turn lane improvements, both the eastbound right turn lane and the northbound left turn lane within the right-of-way. We were able to get those 2 improvements within the right-of-way, which we saw as a great benefit. And here's just a concept that you see of what it would look like over an aerial. You have that in your handout as well. So moving on to the Hollywood Boulevard concept development. Hollywood, the 14th highest volume in the county. There are lack of adequate lanes on Hollywood Boulevard. Again, kind of the same thing with Wickham. The more green time that you have to give to Hollywood, the less that you give to 192. The southbound approach right turn lane over 600 vehicles per hour is a large number. We don't see volumes like this in many locations. Very, very high, very unusual to see a right turn volume at that level. So that's a high number that really drove some of our thinking. The constraints associated with this intersection, the right-of-way available on the South Lake for improvements, that there is no right-of-way available. Again, we're going to be making choices on what we need to do. In order to look at the South Lake, you have potential impacts to the Barnes & Noble on the east side. You have impacts to the former Co-I or the farm store. And then when you look at the north side, there's also potential impacts to the TGI Fridays. And we'll explain how that comes into play. So the concepts that we looked at, the first concept would be adding that eastbound right turn lane, also adding a second southbound right turn lane to address that high 600 vehicle turning movement. The next set of concepts we get into, so you have the concept 1, plus you would be adding a westbound left turn lane and a southbound through lane. In order to do that, you also need to add a southbound catch lane. I can't have 2 left turn lanes going into 1 through lane, so that's why you see that second southbound catch lane concept. And again, 2, 3, and 4 depends on which way you align them through the intersection and what those impacts are. So from a preferred alternative point of view, the south leg of the intersection is planned to be widened from 2 to 4 lanes, and including southbound sidewalks on both sides. So concepts 1 and 2 don't really coincide with that plan. Concepts 3 and 4 are consistent. With concept 3, there are impacts to the Barnes & Noble parking lot that have unknown drainage impacts. The drainage system that's used on that property is a unique one, and once you get into that property and you impact that drainage system, you can be responsible for a lot of impacts that are hard to quantify at this point. Concept 4, therefore, was the preferred alternative. With concept 4, that does involve full parcel acquisitions on the 2 properties of the southwest corner. So let me just kind of go back and update everyone again. So the concept 4 would be the addition of the southbound right turn lane, the eastbound left, the southbound right turn lane, and the southbound through. So therefore, we need those 2 catch lanes. And the properties that we would be acquiring would be the former Co-I property and the farm store to accommodate those alternatives. And this is a sketch of what that concept would look like. I'd also call your attention to the dual right turn lanes, the dual southbound right turn lanes. We are showing a pedestrian island for those separating those dual southbound right turn lanes. That is really a treatment for pedestrians. Dual right turn lanes are not desirable from a pedestrian point of view, so we try and balance the impacts and make that location as safe as possible for the pedestrians in that location. Again, we know that the high number, 600 right turning vehicles, something needs to be done. We're just trying to provide a balance of what those impacts could be. From a cost estimate point of view, you can see on Wickham Road, the 0 right-of-way. That's why that alternative kind of came forward. The design cost that you see is high versus the total cost. The reason that design cost is listed is that's what's listed in the DOT work program. That design cost was estimated when we were looking at a much larger impact, and that's why we didn't choose those impacts. So that cost will be revised probably in the next month or two once we finish the scopes. That's what's available to us. We won't need that level, and that number will go down. On Hollywood Boulevard, you see the right-of-way cost higher than the construction cost. That gets into what we discussed regarding the properties and the impacts. So the next steps in the process, again, going back to the DOT corridor planning process, we've identified the concepts. We are working with DOT to refine the design, the scopes, and the cost estimates. We expect that to be done in November. Once those concepts, the design scopes are completed, the project can move into design, which we anticipate for fiscal year 18. And then based upon the design, we'll see where the construction money comes from. So with that, I'd be happy to take any questions or provide any clarifications.
Thank you, Carl. Any questions?
Carl, it seems to me on the Hollywood, which is the one that has the greatest potential cost, the key decision to be made is whether or not to acquire the properties on the southwest quadrant. Without those additional properties, the additional southbound through lane and the westbound dual lefts can't occur. What about sidewalks? Are sidewalks accommodated if we don't acquire that property? Is there enough room for sidewalks?
No, it'll be, from what we've seen, we would not be able to accommodate sidewalks without acquiring property.
So the additional property in the southwest will also allow sidewalks and
yes, sidewalks are included in the concept.
Right.
And
I just wanted to make that clear, folks. You see the 5.7 million estimate, and even though it's a more expensive option, why that was preferred, even though it doesn't require some right-of-way acquisition.
I would just like to point out that the iStore has been sold, which you put the former iStore. They've been sold, and now there is a dental office that's just getting ready to go in there. So if you were thinking about doing something, you may want to do it before a dental office gets in and established, because moving an existing successful business is a lot more difficult than moving a business thinking about starting.
Yes, we're aware of the transaction that you just discussed.
Any other questions? Carl, thank you very much.
Thank you.
Item 7B on the agenda, staff report.
A single item to report. Due to the elections coming up in November and the timing of the organizational meetings by the various elected bodies, the TPO meeting falls in the middle of all of that, so to avoid confusion and avoid not having the quorum, staff's recommendation that we do not have a November meeting.
Chair would entertain a motion to cancel the November meeting.
So moved.
Everybody move.
Councilman Neal was first and Councilman Green was second. Everybody else is on board. Any discussion, all in favor, say aye.
Aye.
Opposed?
The next meeting will be in December. We'll be back in our regular room for, and that'll be available to us in December.
Item 7C, local government report.
You have at your place, I normally include the report on the Parkway actions. I include that with distribution, distribution of the package, but I was hoping that we could report the approval of the LSPD&E. Here comes Lorena with a smile on her face.
And unfortunately, the answer is no. I checked last night, but I before I left.
It's so close. So, any day now. it's like having a baby, you know, it's like, is it there yet, is it there yet? There's certainly been a lot of labor involved to get this book. October 27th will be the bid opening date for the county section between Palm Bay and 192. The date for the completion of the City of Palm Bay section's been moved back due to all the rain. So December 1st is the estimated completion date. And somewhere around January 12th will be the groundbreaking for the Palm Bay to 192 section. I say somewhere around it because January 12th is a League of Cities meeting, and it's intended to have this after hours, sort of on the groundbreaking, 5 to 6 o'clock, and I think it's in way with League of Cities, so that date may change it. That's all I have. Thank you.
Item 7D, FDOT report.
That was my only report.
Thank you very much.
Other projects, Riviera, the Palm Bay, and the from all being reviewed right now. So we're just waiting on comments on that. And the other projects, a few of them were delayed due to rain, but they're back on schedule now. So everything's working.
Rain's affected
A lot of projects, yes.
Any questions for Lorena?
I have one. On the US 1 north of Sitco Road to Golden Knight Boulevard, is that strictly the paving or is that widening as they're doing coming up north of Boulevard?
That's some winding in that area.
So it's widening up the Sidco Road, it's part of the US 1 winding
How
project.
far is that plan?
Sidco Road, as far as the work is the widening will go.
How far north?
Sidco Road, which is just about, 3/4
Within
mile or
those
so north of the interchange area.
So it's not coming from the
No,
north?
no.
Okay, thank you.
You want it further north?
There's our advantages and disadvantages, and your opinion would be my own.
Lorena, I know back in late September, the city of Cocoa sent you an email about some changes that were taking place several years ago, and I don't even remember if you were around in those days. We had asked for PD&E for State Road 524 because of the potential development at the corner by 95 with 524, and you all had recommended that that be put off because of the
Traffic studies are now going.
yeah. So we sent you an email asking if we could move that up because of potential sale on that property. And so can you give me an update of where we are in that?
Okay, currently, the PPE that is on our work program is from 501 to industry in Michigan. And we're going to move forward with that. Once that acquisition is final, then we'll take some of that into consideration within the limits of that project. But the 524 now has to go back through the TPO process to be put on your priority list before we can move forward with another study on that project.
All right, well then, it's Mr. Allender and I will be discussing that. Thank you.
You're welcome.
Any other questions? Thank you very much, Lorena. Item 8 on the agenda, public comment. Seeing none, then the chair will entertain a motion to adjourn.